that case is that the timing of the litigation, when that lawsuit was filed, I believe 3 days before the worldwide release of the Hangover. So for them, it kind of put Warner Brothers back up against the wall. They've already spent $100 million in advertising or whatever in distribution, and now it's like either you settle or you're facing an injunction and you have to pull the film from all of the releases and reschedule all the premieres.
It was well timed.
So, yeah, so what you're describing is good wiring.
Yeah.
And that happened in the case of, what's the Daisy Dukes? Dukes of Hazzard. You know, there was an argument about whether the Warner Brothers had the rights, had properly acquired the rights from the television show, and they got an injunction, the lawyer did, and Warner Brothers had a cave on that particular situation. Although I understand there's reason and authority in which courts are saying, hey, we're not going to grant an injunction, just because it's infringement of some sort. So it's not a P.L.C.
But those kinds of issues, you know, cross over, you know, to trademark issues. I mean, when I was general counsel of Major League Baseball properties and Major League Baseball properties, we had many instances where uniforms were being used in scenes and films and, you know, things like that. They send out cease and desist letters and immediately get a license or arrangement in place because they know they didn't want to have something obstruct the distribution of this project that they spent, you know,
Can I ask you a question? Why can't I? It seems to me natural that I should be allowed, if I want to, and I'm in a film, to have one of the characters wear a Dodgers uniform. Why could Major League Baseball the Dodgers stuff?
because we own the trademark.
So what?
We own the
It's
trademark.
art.
No, it's not art. It's a trademark. And by using it, you're associating that brand with that film, that character in that film.
Is there a case law? That seems so unfair.
No, it seems unfair, but we bring that.
I mean, what am I, a Ford? The guys drive, wait a minute, the guys drive. The guy's driving a Cadillac. Cadillac's I have to get a license from Cadillac?
Yeah. Oh, you're just gonna put advertising in.
The guy's drinking a Coca-Cola.
Product placement.
That's maybe, I'm sure Coca-Cola would like to have it in the film, but I can't believe that every item in the world, somebody has to go get a license for to make a film or a television show. You think so?
I think so.
You're on the licensing side.
That's why these brands pay to have their brands in these films. You know, instead of Leno, the X Factor. I mean, there is value in having the exposure to that audience.
I think the Mike Tyson tattoo brings out another interesting that factor or factor that is related to defamation of privacy that might help one of those causes of action, and that's whether you're an intellectual property attorney or a business law attorney or a contract attorney, and you're doing only transactional work, you should always consider the intellectual property ramifications about your client's business. And I'm asked on almost a daily basis, and I'm exaggerating to make a point, about ownership of intellectual property. And artists are always looking at asking that question because they want to know what they can protect and what they can't protect. So if Mike Tyson, as part of his entourage, would have had an attorney with him, he might have thought, well, this tattoo is going to distinguish me. This could be my trademark. I'm going to own the intellectual property rights to this tattoo. So the tattoo artist then would sign a work for hire agreement, and he would have no rights to that tattoo. That's another way of handling it that would also give Mike Tyson the right to bring copyright infringement, but it might also fit into some of these categories we're talking about today because fundamentally he owns all the rights to that design, and he could make other causes of action, or might be able to conjure up other causes of action as well.
We should mention the No Doubt case. That's a 2011 California Court of Appeal. By the way, I've given a handout I've got beside these cases, but there, Gwen Stefani and the band went after the video game band Hero and said, you're showing my likeness in a video game, you can't do that, and I know you're claiming it's not really me, etc., but it really is me because it was one of her songs, and she was able to prevail. The same thing happened in Keller versus Electronic Arts, which is a 2010 case, which is on appeal, where they used the image and likeness, and so
even if they change it a little bit, that may not be enough. And then the Three Stooges case is the big important case. That's where they made a charcoal rendering of the Three Stooges, and the court said, not enough, you're liable for that. And we see that all the time. I mean, I was talking to one of the fellows here today who's representing, you know, as soon as you get a celebrity in the world, I mean, they're all over you to try and make a buck off of it. If they don't have to pay for it, they're going to try and do it, and they may change some variation of the person's name and all the rest of it. But the creative force is confusion and or if you're trading on the person's name. The other interesting case was Paris Hilton against Hallmark Cards, 2009 Ninth Circuit, where they used one of her catchphrases and images, and they're trying to say it's art. And the court said, no, you're trading on Paris Hilton's, you know, shtick, so to speak. So you can't do it.